Breaking news. Welcome to today's headlines. Nnamdi Kanu appeals court judgment, retaining 7 of 15 charges against him. Nnamdi Kanu appeals court judgment, retaining 7 of 15 charges against him. To my dear listeners, from wherever you're listening from, please stay tuned as I read today's news. The leader of the indigenous people of Biafra, HIPOB, Nnamdi Kanu, has appealed a recent ruling of the Federal High Court which struck out 8 of the 15 count charge filed against him. Kanu had been standing trial on an amended 15-count charge, bordering on treasonable felony. On April 8, the judge, ruling on Kanu's application on Friday, struck out count 6, 7, 9, 10, 11, 12, 13, and 14. This means the IPOB leader is to stand trial on counts 1, 2, 3, 4, 5, 8, and 15. But in the appeal issued on Friday and signed by his lead counsel, Mike Ābuse, Kanu prayed the court for an appeal in Abuja to dismiss the remaining charges against him and discharge him. The separatist leader faulted Yako's ruling on the case, arguing that the judge erred in several areas which amount to a miscarriage of justice. It reads, Ground 1, Error in Law. The learned trial judge erred in law when he failed to consider, make a finding of fact, and accordingly pronounce on issue one raised for the trial court determination relating to the extraordinary rendition of the appellant and thereby occasioned a miscarriage of justice. Ground 2, Error in Law. The learned trial judge erred in law when he held that the defendant is being charged under Section 1(2) of the Terrorism Act, which has been reproduced above any offense alleged to have been committed within or outside Nigeria, can be brought under the Act, thereby occasioning a miscarriage of justice. Ground 3, Error in Law. The learned trial judge erred in law when he held that although the status of the indigenous people of Biafra as a proscribed organization is a subject matter before the Court of Appeal, but as long as the appeal has not been determined, the order of court proscribing is still in force until set aside, and thereby occasioning a miscarriage of justice. Ground 4, Error in Law. The learned trial judge erred in law when, in the exercise of the powers conferred on him by Section 2164 of the Administration of Criminal Justice Act 2015, suo motu amended Count 15 of the charge, which is founded on an allegation of importation of a radio transmitter in Obulu Si Uzo in Iyala local government area of Anambra State, and proceeded to assume jurisdiction over offenses allegedly committed outside its territorial jurisdiction and thereby occasioned in a miscarriage of justice. Ground 5 Error in Law. The learned trial judge erred in law when he held that trials before the Federal High Court are summary and consequently ruled that counts 1, 2, 3, 4, 5, 8, and 15 show some semblance of allegation of an offense on which the court can proceed to trial and thereby occasion the miscarriage of justice. The leader of the indigenous people of Biafra, IPOB, Nnamdi Kanu, has appealed a recent ruling of the Federal High Court which struck out 8 out of the 15-count charge filed against him. Kanu had been standing trial on an amended 15-count charge bordering on treasonable felony. On April 8, Binta Nyako, the judge, ruling on Kanu's application on Friday, struck out counts 6, 7, 9, 10, 11, 12, 13, and 14. This means the IPOB leader is to stand trial on counts 1, 2, 3, 4, 5, 8, and 15. But in the appeal issued on Friday and signed by his lead counsel, Mike Ozakome, Kanu prayed the Court of Appeal in Abuja to dismiss the remaining charges against him and discharge him. To my dear listeners, now I've come to the end of our today's news. Please do drop by at the comment section and let us know what your view is all about. Thank you for listening.